Welcome back to This Week in Immigration, our in-depth look at what really mattered this week in immigration policy. I'm Jordan Lapierre.
And I'm Hunter Hallman. On the show this week, we'll check in on the DACA debate, get an update on the court cases against Trump administration's immigration policies, look at new ICE guidelines on arrests in courthouses, and discuss the travel ban.
You can subscribe to this podcast and all of BPC's podcasts on iTunes or your favorite podcast app, or stream on our website at bipartisanpolicy.org.
And while you're there, you can find more information about all the topics we discuss on the podcast. Just go to bipartisanpolicy.org/immigration.
Let's welcome in once again Theresa Cardinal Brown, Director of Immigration and Cross-Border Policy, and Cris Ramon, Policy Analyst on our immigration team. Hi as always.
Hey.
How you doing?
Great to be back.
Theresa, let's start the way it seems we always do on this program with the unfolding DACA debate. Can you just give us an update on where things stand as we're staring down another government funding deadline this week?
Right, so as we record this, the government is set to shut down again in 2 days. There does not seem to be any deal on the horizon legislatively for DACA at this point in time. The members of Congress and leadership seem to be focusing most heavily on the funding of the government. It seems like the DACA issue is mostly at this point decoupled from that vote. So I think it's unlikely that we're going to get something voted on this Thursday on the 8th. That having been said, the latest on the government shutdown is that it is unlikely to shut down. And if you remember, that was one of the preconditions that Majority Leader Mitch McConnell in the Senate made at the last shutdown, that if the government remained funded on February 8th, then he would allow a vote on the floor on DACA legislation. If there was a deal, he would put that on the floor. If not, he'd put something on the floor and let people debate and vote on it. So I think at this point in time, that appears to be where we're headed, that sometime Friday, early next week, the Senate will proceed, or the Majority Leader will ask for a motion to proceed to some form of debate on immigration legislation. What form that will take, whether that will be one of the bills already introduced, whether it will be some sort of the president's framework that he outlined, whether it will be something brand new or just a skeleton piece of legislation, we still don't know yet. But it does seem that at least the Senate will proceed to some sort of debate on this next week.
So at least for now, in your view of this, all the sides are holding up their ends of the bargain in this arrangement.
Well, to the extent that was the deal that was struck in the Senate to reopen the government last time around, yes. It appears that at least, right now, and again, as we were recording this is what seems to be coming together.
Right.
Congress is known for things coming together and falling apart, so I don't want to speak into the future.
And this stuff changes hour to hour.
It does. But as of right now, we're recording this on Wednesday before the vote, that those things appear to be where we're headed. But again, no grand bargain deal on DACA right now.
So we've discussed why March 5th is not really a deadline anymore. But is your sense that Congress is still operating under the idea that March 5th is a deadline to act? Will we see them act before?
So it kind of depends on who you're talking to.
Okay.
One of the things that we have been hearing increasingly from certain members of Congress is that, well, it may or may not be the deadline. And here's why. A couple of things have happened. There was a U.S. District Court case out of California that ordered the Trump administration to restart accepting extension applications for DACA. That had nationwide effect. That went into effect in mid-January. So right now, DHS is accepting applications for renewal of DACA applications for people who have previously had it. Not new applications, but renewals. So technically that's happening right now. The government did not appeal that to the district court. They didn't ask, that would be the normal next step. Appeal to the district court, ask for a stay of that injunction. They didn't do that. They skipped straight up to the Supreme Court and asked the Supreme Court to rule on the underlying case. Now that's very unusual, but it also means that until the Supreme Court decides whether or not to hear the case, DHS is going to continue processing these new applications. That's not a be-all, end-all. Supreme Court weighs in, it all goes away. We don't know how long it's going to take DHS to process these things, but right now that's ongoing. So that's sort of one thing that makes this March 5th date fuzzy. The other thing that had been floated out there by the president himself at some point is that he would just extend it. That seems to be shut down today. Chief of Staff to the President, John Kelly, did a press scrum with a bunch of reporters in which he said, I really don't believe the president is going to extend DACA, in part because the argument for ending it in the first place was that it was unconstitutional for any president to have created this program. It would be unconstitutional for him to extend it. So General Kelly seemed to think that that is not on the table, so that won't extend March 5th. That having been said, we know that people are losing DACA status now. People who may have already lost DACA status may not be able to apply for these renewals. And we know that, regardless of what happens in the Supreme Court case, that's sort of an iffy thing. We know that the government wants to end the program. They've asked to end the program. They just haven't go so far as to ask the courts to allow them to kill it now. So that puts everything still in a limbo. That having been said, I still think there are an awful lot of people in Congress who would much rather get this finished and taken care of earlier rather than later. Whether or not March 5th is a deadline or not, certainly for a lot of Democrats, they want to see this problem permanently fixed. I think for a lot of Republicans, maybe they have a lot of dreamers in the district, they want to see this fixed as well. And then there's the fact that we are in an election year. And I think there's a lot of people that may not want to have this issue carry on through to the elections, that it would create either one way or another problems for them. Particularly, I think a lot of Republicans may not be wanting to vote on this too close to their own election prospects. So getting it off the table and over and done with earlier is better. So in terms of the deadline, that's the status. The one thing I would say about the Supreme Court, so the Supreme Court asked for briefs on whether or not they should take this case right now and skip the district court. Those briefs were due end of last week. We know that both sides made their arguments. The Supreme Court has not yet ruled whether or not they will take that case. If they say yes, we will hear it. They may not hear the case until June. They may not issue a decision until later in the summer. And so that will also have implications for whatever happens.
So how might the decision in that case, if the Supreme Court does decide to take it, impact how Congress negotiates on DACA?
Well, we have seen in the past that when the Supreme Court had something that was working on, that Congress tended to punt the issue. So I could very easily see that if the Supreme Court takes the case and would decide one way or another whether the program would continue or not, they might decide to wait until the Supreme Court had ruled. That having been said, that's not great for the dreamers because, again, that extends their sense of we have no idea what's going to happen. And for those who employ dreamers and those who work with dreamers and those who have dreamers in their family, this is all very, very anxiety producing. And so that's not the best outcome for them. And again, we don't know which way the court will rule on this. Ultimately, they have to decide. At issue in this case, frankly, is partially whether or not the DACA program itself was legitimate as an executive action, but also the way the Trump administration ended the program. That's at the heart of this particular court case. Did they end it too abruptly? Did they end it without appropriate notice and comment under the rulemaking laws? If those are the cruxes of this court case, it would not obviate the need for Congress to act anyway, because it's never going to provide a permanent solution. They could come back and just say, you have the right to end the program, you just didn't do it properly. And then the administration would come back and say, okay, we're ending it properly. We'll now give you, 3 months warning, but it's still going away. And then, we're back where we started from. So all things considered, I think the one thing that most people do agree is that the ultimate solution for this lies in Congress. They're going to have to act at one point or another to get it done.
Great. Thanks for laying that out for us, Theresa.
Sure.
I'll turn now to my co-host, Hunter Hallman, to talk a little bit about another of our recent blog posts explaining ICE's new policy guidelines on courthouse arrests. So, Hunter, ICE's guidance on enforcement operations in courthouses recently became available to the public. What do those actually say?
Sure. So, for some context, first and foremost, ICE has something called sensitive locations policy that we've also written on in the past, which basically sets out guidelines for ICE that they shouldn't go into places of worship, healthcare facilities, gatherings like weddings or funerals to apprehend immigrants. And these are just guidelines for ICE to act by. So courthouses were not included in sensitive locations policy, but ICE has been getting some backlash on operations that they've been conducting in courthouses.
Right.
So they put out these guidelines last month, January, and they recently became public. They specify that the actions they're taking in courthouses should be against specific aliens, so those with criminal convictions, those who are gang members, or national security or public safety threats. They specify that if they encounter immigrants who may not be here legally that are witnesses in court cases or family members of the specifically targeted alien or friends of the person at the courthouse, they should not be apprehended for deportation. And that they should be discreet and generally avoid making a scene, basically, in courthouses, trying to go into places that aren't public, maybe, so not like, bursting into the courtroom and apprehending someone, and that they need to get specific approval for operations in courthouses. So they have to go to a certain regional person who's above their certain level to get permission to go into courthouses to conduct these operations.
So obviously critics were saying courthouses are an unfair place to conduct these immigration enforcement activities, but ICE not only disagreed with that, but they listed some benefits to doing these operations in courthouses.
That's
what,
right.
What do they say were the benefits?
So they say the main thing is safety, and that's for the public, the person that they're apprehending, and for the ICE agent themselves, of course, because there are usually law enforcement members present in courthouses, and people who are entering are being screened for weapons and contraband and things like that. So it just makes it safer than any old operation on the street. They're actually going somewhere where they can pretty much guarantee a certain level of safety that might not exist outside of that courthouse. But they also point out that courthouse arrests, and I'm quoting the memo here, are often necessitated by the unwillingness of jurisdictions to cooperate with ICE, which is a reference to so-called sanctuary jurisdictions that may not comply with requests from ICE to transfer custody of aliens to ICE out of their county jails. So they're kind of putting the onus back on the jurisdiction in that case, which I think is an interesting tidbit from that memo.
So how is the advocacy community reacting to these new guidelines?
So it's been a mixed reaction. There actually have been some positive reactions from the advocacy community, which is encouraging. Some are applauding the guidelines as a good starting point, and they say that it shows a willingness on the part of ICE to listen to public response, which is good. Others are saying that the guidelines don't do anything really to stop undermining immigrants' constitutional rights, more kind of for show than real progress, because they're not necessarily changes to any law. They're just guidelines. And it includes a disclaimer, the memo includes a disclaimer that the policy can't be used, for example, to sue ICE. Like, you wouldn't be able to take this memo to court and say, my rights were violated, see this memo, I get this benefit in a courthouse. That doesn't exist.
I think the important thing to ask here then is how much will these new guidelines change the way ICE operates?
So, as I said up front, broader sanctuary city policies are not legally binding, and these courthouse policies aren't binding either. ICE does have broad authority to operate pretty much wherever and whenever it's deemed necessary. But I think the provisions about not deporting friends or family just because they're there, and especially the approval requirements for courthouse operations, should give heart to advocates, in the absence, at least, of any legal precedent or congressional act on the subject, which would make these things binding.
Okay, thanks, Hunter.
Of course. Let's pivot to a couple of big reports we've seen come out that detail the intersection between immigration and national security. And those would be the travel ban and the recent terrorism report. Theresa, the Department of Homeland Security Office of the Inspector General released a redacted version of a report that found that CBP may have violated court orders in its implementation of the first travel ban issued a year ago. DHS apparently held up the release of this report for 3 months over the objections of the now retired OIG John Roth. What exactly does this report say?
So thank you. So this is a very interesting report. Most of us remember what was called the chaos weekend at the airports. The weekend after President Trump was inaugurated, one of his first acts was to issue a set of executive orders on immigration, including what's now called Travel Ban 1.0, because we've had several versions of it. And the executive order was put into effect immediately upon signing, which meant that it affected people who were literally en route to the United States. And it was issued on a Friday, which meant that for all intents and purposes, CBP, the Customs and Border Protection, the people who operate the ports of entry, were sort of rushing to figure out what was in it, what it meant, and how to implement it on a weekend when most of official Washington has gone away. And so a lot of people remember there were mass protests at a lot of airports about this. There were emergency court injunctions issued over various parts of it that weekend. There was a lot of activity, and there was a lot of questions about, how was this executive order drafted? Who knew about it? Why was CBP so sort of caught by surprise? So this Inspector General report actually goes through the timeline of the drafting of the EO, the issuance of the EO, what happened over that weekend and all of the following days. And its conclusions are pretty stark. A couple of things that it makes very clear is that the Secretary of Homeland Security at the time, John Kelly, actually had very little input into the drafting and or notice. He had seen a couple of drafts of it in the couple of days prior to its issuance, but no one really knew that it was coming right then and it was going to be effective immediately. No one at Customs and Border Protection, which would be charged with implementing this, had been involved in the drafting, had seen it. They first got wind of it through an email about the time it was issued. And so they were scrambling after the fact to develop operational protocols, policies, procedures, answer questions for its people out in the field. So this lack of preparation led to a lot of what happened at the ports that day. And then because the advocacy community reacted so strongly and so quickly, and a lot of people went straight to the courts, the fact that you now had then court orders enjoining the department from doing certain activities that they were still trying to figure out how to do in the first place created more of a chaos environment. So a lot of the, I think, portions of this report actually validate what most of us kind of understood, that this was a chaotic rollout, that there was an awful lot that was not thought about before it was put into play. Regardless of the underlying policy, the way it was carried out probably contributed to a lot of the negative pushback against it from day one. And the other, thing that makes it sort of questioning and controversial is the idea that this report, by law, Inspector General reports must be submitted to the department. They get to comment on it. They can object to certain recommendations that are made in the report, but then both their comments and the recommendations are usually provided to Congress and or made public. The Homeland Security Department refused to release this report. One, they disagreed with all the conclusions of the Inspector General. And did not want it released. They thought it would affect law enforcement operations, that it revealed too much about sensitive discussions inside the department. And eventually, I think due to a lot of public pressure, in part because the Inspector General went to Congress and said, I have this report, Homeland Security won't let me. A lot of members of Congress pushed on them to release it. They finally released it. The last thing I would say that makes this report somewhat unique, I've seen a lot of these reports when I worked at DHS. I was one of the officials who would be responsible for reading the Inspector General reports and commenting and helping provide information that might be part of the department response. Usually when there's redactions made to a report, those redactions have to do with maintaining classified material or things that are law enforcement sensitive, and there's usually a reference to the provision of law or regulation that allows those portions to be redacted whenever you redact something. That's not here. It just says the redactions were made by the Department of Homeland Security. There's no reason given for any particular set of redactions in here, so we don't really know why the department chose to redact any particular portions of this. So that's also kind of an unusual thing to see. Certainly, I think that there's what ultimately comes out of this is, I think, something that this administration actually learned by Travel Ban 2 and 3.0, which is it is always better to involve the people whose job it is to implement something earlier rather than later in the process. It is better to figure out what your public relations and media strategy to roll this thing out is going to be before you put it in place. That just seems to be common sense. And I think, in the first week of the administration, they clearly didn't have that all figured out.
So you mentioned the advocates being quick to go to the courts to try and get some of these first provisions blocked. And as we know, there's still ongoing litigation about the travel ban. Do you think there's a chance this report might affect that litigation going forward?
It might. It might. The Supreme Court just agreed, I think, to hear the latest version of the travel ban orders. I think, look, the legal arguments against the travel ban, for the most part, have centered on this idea that the purpose of the travel ban wasn't the security arguments that were made. It was really fundamentally about being anti-Muslim or against people from certain countries. And I think that certainly those who are filing these cases will look at this report and say the fact that the operators were not involved, the people whose job it is to decide whether somebody is a risk to come in the country, were not involved in the drafting of this executive order, is maybe further proof that the people who drafted it really didn't have enough knowledge or understanding of those concerns to make them the basis of the thing. We'll see when the next court filings come in, but I'd be really surprised if this report wasn't referenced in at least one of them.
Interesting. Thanks, Theresa.
Sure.
Turning now to another high-profile release, the Department of Justice recently issued a report asserting that 75% of individuals convicted of international terrorism-related offenses in the United States were foreign-born, bolstering the Trump administration's case for so-called extreme vetting and its travel ban. But critics have said the report is misleading. Cris, what is the deal here?
So it's interesting because, we're talking about the OIG report and the origins of that, which is Travel Ban 1.0. And as a part of that executive order, the Trump administration asked that a report be prepared on basically the presence of foreign-born individuals in international terrorism-related offenses. That's specifically what they were looking for. And this is actually a broader push that the administration has been doing. They've also, in an executive order on interior enforcement, they also wanted a report on the presence of criminal aliens in federal prisons. So it's just sort of this broader push for them to be able to release this information to the public. As you said, basically the report found that 73% of those convicted of international terrorism offenses were foreign-born. In hard numbers, that means, 549 individuals is what they found. And of those, 148 were foreign-born and naturalized, and 254 were not U.S. citizens. So that kind of gives you breadth of that. But it's also worth noting that among those numbers, you have 27% were native-born Americans. And this is actually pretty important because, we're sort of talking about the criticisms that people were leveling. So there's a couple of those that I think are important to know. One is this whole notion of foreign-born versus domestic terrorists, right? Mm-hmm. That the report really places an emphasis on foreign-born. But if you're looking at what other reports or other centers that sort of look at these issues, they actually find something that's a little bit different. The Center on National Security at Fordham University's law school, they track terrorism cases in federal court. And what they've been doing is looking at more recent Islamic State-related convictions. And what they found is that basically the proportions between foreigners and Americans is about 50-50. So that's something that's important to note. The Cato Institute also, tracks, they produce reports on terrorism and the presence of foreign-born and terrorist attacks. And what they found is that, if you're looking at how many people were killed by terrorists on U.S. soil, what they found was, since the beginning of 2002, native-born Americans were responsible for 78% of all murders and terrorist attacks committed on U.S. soil, while foreign-born terrorists only committed 22%. So that's one area that you start seeing that it's not just simply foreign-born, but you're seeing, native-born Americans who have been radicalized who are committing these attacks.
Well, how do you explain that enormous discrepancy between these two studies?
Basically, what you're looking at, if you're looking at the studies, it's always a question of what question are you asking, right? It's always a question of how you're defining foreign-born, how you're defining native-born, how you're defining metrics of terrorist attacks, what kind of attacks you're including. But I think what's important to kind of pivot back to the report is that the report, is specifically looking at foreign-born individuals in international terrorist-related offenses. That international terrorist-related offenses is actually a kind of a tricky term because, as the Cato Institute has noted, that's actually not a term in statute. It's actually more of an administrative term that there is no statute saying you can be convicted of terror-related offenses. That's something that's more administrative. So it makes it a little bit more ambiguous as what falls under that rubric. It could be terrorist attacks. It could be something else. So that's always something that, you can explain that discrepancy is both, who's committing it, how are you measuring those individuals, and what are they committing, and what they've been convicted of.
So some critics of certain immigration programs have said that the immigration system is being exploited, which is leading to some of these terrorism offenses. What do we know about the extent to which there's a connection between those two things?
So what's interesting about this report is that the report doesn't actually illustrate how these individuals arrived to the United States. There is no data on the visas that they used, right? It's not there. What's also a little bit ironic is that this report that came out of Travel Ban 1.0 actually doesn't indicate how many of these individuals came from the banned countries from the first travel ban. But if you want to kind of get a sense of, well, what does the data actually say? So the New America Foundation has a project where they've been tracking terrorist attacks since 2002. And in the data that they have, what they've been able to find is that 85% of all the terrorist attacks that they've been tracking, 85% have been, perpetrated by citizens and permanent residents, and 15% have been, perpetrated by non-residents. If you dig in a little bit deeper, within the numbers that they have, you have 92 naturalized citizens who fall in this database. And of course, when they say naturalized citizens, we don't know how they came to the United States, so it makes it a little bit harder, trickier to say, how they came to the United States with visa systems that they used. But at the same time, they're able to kind of note out a couple of things, which is there are pretty small numbers of non-immigrant visas, small numbers of visa-free travel eligible individuals, very small numbers of illegal immigrants, and 18 who are refugee or asylum seekers. These are really, really small numbers. So I think it's important to kind of take a look at this data and go, what does this say about the way that our immigration system is structured? Does it present a national security threat? And at least with the New America Foundation data, it shows that no, not so much. I mean, half of them are being perpetrated by U.S.-born individuals, and the other ones certainly presents causes for concern, but the level of screening that I think we present for all individuals who want to get visas to the United States certainly is a way that can counteract any potential, quote-unquote, exploitations of the system.
Thanks for breaking down the data, Chris.
And thanks to all of you. That is the show for this week. Please take a second to find us on Facebook by searching Bipartisan Policy Center or on Twitter at BPC_bipartisan.
And again, don't forget to subscribe to this podcast as well as all of BPC's podcasts on iTunes or wherever you get your podcasts by searching Bipartisan Policy Center. Join us again next time.